just go for it. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus, and to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? And lastly, under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Whenever you're ready.
The writ of habeas corpus, also known as the Great Writ of Liberty, prevents the government from arresting and detaining people without reason. According to William Rahl, a former Philadelphia district attorney, the writ of habeas corpus is the great remedy of the citizen or subject against arbitrary or illegal imprisonment, 1829. The writ is essential to limited government because, as we can see in the Rogers versus Trade case, it can make sure the government doesn't violate the due process clause for any reason. Another reason that it's important to limited government is seen when looking at government censorship, because it allows people to have their First Amendment rights and be allowed to speak out against what they dislike, especially the government, without the fear of being thrown in jail. It can also be used to protect non-citizens from being illegally jailed by the government. Habeas corpus is essential to keeping the government in check and protecting citizens and non-citizens alike.
Addressing the first point, the writ of habeas corpus had a notable role in the founding of our nation, to the extent that it was included in the Constitution. It was taken seriously to prevent despotism that would ruin the ideal of what our nation was intended to be. But it was being ignored as early as Lincoln's presidency when he illegally suspended the writ and detained citizens for voicing opinions on the war. This creates a dangerous precedent where any president could suspend the writ for any sad emergency. To see a recent example, we can look at Guantanamo Bay, where prisoners have been held without legal means to challenge their detention, even with two Supreme Court cases being from 2004 and 2008 ruling against it. The framers meant for the writ of habeas corpus to hold much more ground to protect many more people than it does in our modern society.
As Alexander Hamilton stated in Federalist 84, the practice of arbitrary imprisonments have been in all ages the favorite and most formidable form instruments of tyranny. We see that the writ of habeas corpus has struggled to sustain purpose since it began evolving in the United States. In 1789, the federal courts were granted the ability to issue a writ of habeas corpus, and the statute was then further expanded in 1867 by Congress, extending the ability of the state to issue the writ. In 1948, Statute 28 U.S.C. 2255 was passed, which gave detainees accessibility in asking the court to vacate, set aside, or correct a sentence if it was unconstitutional. Another evolution of habeas corpus came with the Anti-Terrorism and Effective Death Penalty Act of 1966 that put a one-year time limit on when all 2255 motions could be called for, making a second or successive motion nearly impossible.
To answer the last bullet, the writ of habeas corpus is not an unreasonable burden on the government. According to the founders, habeas corpus was a fundamental right which prevented the government from locking up whoever they wanted to without cause. So in a sense, filing habeas corpus could be thought as proving your innocence to a government who already thinks that you were guilty. That is not how the system was designed. It was designed so that any individual being accused of a crime is innocent until proven guilty. In the court of law, habeas corpus is considered a civil lawsuit in which the prisoner brings the lawsuit forward and is considered the petitioner and has the burden of proving innocence. In many cases, when the government is holding an individual without reason and habeas corpus is filed by the individual's attorneys, they hear little to nothing from the government on why their client is being detained. All the more reason why habeas corpus is more of a burden on the individual and not the government.
Lastly, we must consider the general effectiveness of petitioning for a writ of habeas corpus in the court system. You can only file for a writ of habeas corpus after all other options, such as appeals, are exhausted. On average, the petition itself will take approximately 3 years to reach an initial verdict, extending the entire process to well over a decade. The Bureau of Justice Statistics found that only 3.2% of petitions are granted in whole or in part, and even then, only 1.6% of granted petitions lead to any release. This could help prove the burden from the petition's abuse. However, this does not explain the minuscule rate of granted petitions to result in any action. To continue off of Hamilton's Federalist 84, the establishment of the writ of habeas corpus and the prohibition of ex post facto laws are perhaps greater securities to liberty and republicanism than any it contains. We are now ready for your questions.
All right. Thank you very much. I want to start on the suspension clause. Article 1, Section 9. It says what it says. It's kind of vague. So I would like just to get your thoughts on, what do you think about the wording of the suspension clause in terms of the reasons allowable? And is that language appropriate today in our country? And can you think of any ways that that might be dangerous if we leave it as it is?
So I do agree with the wording's a little iffy. And to answer that last point, I think a point could be made in the Capitol riots that they could have suspended habeas corpus because many considered it as a rebellion. So in a sense, I think that could be a little iffy because some considered it as a rebellion, some did not consider it as rebellion. So I think in a sense that could be testing the waters a little bit.
I also do think that it leaves a lot of unclarification on who necessarily can suspend the writ. I know we have to go back looking into who proposed the writ of habeas corpus when they were drafting the Constitution. It was Charles Prickly, and he actually had in there before it was amended that he wanted it so the legislator themselves could take and suspend the writ. And I think that's kind of generally accepted today that Congress is the one who has the authority to suspend the writ. But even at that, I think the causes that Congress can suspend the writ for kind of can be widely interpreted whatever Congress wants them to be.
And a big point to note here is actually the differences in state constitutions as well. If you look towards the Constitution itself, we can see that the writ of habeas corpus can only be suspended in these certain instances, such as rebellion, as we've talked about. But if you look towards other state constitutions, using the example of our Montana Constitution, it says the privilege of the writ of habeas corpus shall never in any case be suspended. So it is also important to look at these individual state constitutions when we look at suspending this writ of habeas corpus.
Great, thank you.
I want to, I'd like to go back to the famous example of Lincoln in the Civil War suspending habeas corpus. It was mentioned in your opening statement briefly that it was an illegal suspension of habeas corpus. I wonder if you could just elaborate on that a little bit for me. So some of the historic context, what he was trying to do, and why we've reached the conclusion that his actions were illegal.
So what happened there is we see that Lincoln had no power to suspend the writ, first of all. It was Congress's decision to make, and he chose to make that decision. And it was border states, and it was border state newspaper writers specifically that were writing opinions against the war. And that was very important in like a turning point of the war. So we see that he was jailing these people in order to help his war effort, but that it was illegal not only in how he did it and just illegal in general and not a good thing to do.
We can also see that there were no repercussions for what he did to him as a president because Congress, after the fact, after he suspended the writ, said that they approved of his suspension, but he never got the permission beforehand to do so.
And dating back all the way to, so 1861 is when Chief Justice Roger Taney said that this is unconstitutional, but Roger Taney didn't have any authority over Lincoln, he thought. And then 2 years later, Congress gave Lincoln the power to suspend the writ.
To add in on Chief Justice Robert Taney, he actually had a quote that said something along the extent of, if the executive power alone held the authority to suspend the writ, it would undermine the very purpose of the writ. And I think we definitely see that in Lincoln's case.
Thank you.
I wanted to follow up on a comment I believe you made in your essay about the writ protecting citizens and non-citizens alike. Can you expand upon that a bit? Where you made that statement, can you give some further support to it for those two groups? Where would that authority lie?
So we see that there's been Supreme Court cases going along with this, such as Yicklow versus Hopkins, where this gave non-citizens the right to habeas corpus and made it so that they had the same rights as citizens do.
However, in the case of Guantanamo Bay, as we stated in our prepared remarks, this has been ignored for these non-citizens because we have seen them as a threat. And our idea of this would be giving them a trial in the first place, considering they're being held there without this trial. So we have the ability to remedy this problem that we have in Guantanamo Bay if we simply held a trial, but we haven't done so, and these non-citizens are not being held with this clause.
We can also see that in another case, while the prisoners at Guantanamo Bay have not had their trial. We can see in 2010, there was a ruling that allowed the enemy combatants at Bagram Air Base in Afghanistan. They are allowed to file for habeas corpus and they are allowed to have their trials. So the fact that the prisoners at Guantanamo Bay have not had that opportunity shows that there should be some remedy and there should be some evaluation of those court cases, the fact that they were ignored.
Okay, thank you.
Well, what kind of remedies might you recommend?
I definitely think one remedy would be giving the Supreme Court some way to enforce their actions. The Supreme Court has neither the power of the person or the sword, and I think that's kind of what we run into trouble with, especially in like Budeman versus Bush, where they said that Congress and the President Bush's acts were illegal, and the president pretty much just disregarded their decision in totality.
And even then, just restoring this idea of checks and balances, because not only was it ignored, but the Congress actually passed a different bill completely superseding any rulings that the Supreme Court made in both cases. So restoring this idea of checks and balances, which we've seen be the core principle of this Constitution, would also be a good remedy to the solution, as my colleagues say.
Let me ask a question that's maybe a little bit broader, but at the core of this discussion of habeas corpus is this tension between civil liberties, individual rights, and the collective good or public safety. So setting the topic of habeas corpus aside for a moment, are there other instances in our history you can think of where civil liberties or individual rights were set aside in the name of the public good? And do you think that was justified in those instances?
Well, we see this almost all the time in modern instances where we say, like, we try to sacrifice rights for safety and really end up with a little bit of safety and just giving up rights, possibly permanently. We can even see that people gave up rights to go to church and express religion during the COVID-19 pandemic, and we see similar examples.
And even tying this all back into the idea of this writ of habeas corpus, a lot of these have been postponed due to the COVID-19 pandemic because courts weren't able to hear these cases. And that not only does that violate the prisoner's right to the writ of habeas corpus, but that also violates the idea of the Speedy Trial Act and having it in place in the first place. The trials are supposed to be held within 70 days of the Speedy Trial Act being established in the first place.
Time.
You can please finish that thought.
Through the COVID-19 pandemic, we have simply seen all of these being delayed, and we have seen these violations to the Speedy Trial Act and to the writ of habeas corpus and these prisoners' rights.
Thank you.
Well, yep. That's the one thing I really miss about doing these Zoom thing. I don't get that round of applause that you all deserve. If you earn. So congratulations. That was I hate it when time runs out because we're just engaged in a great conversation. And that just energizes me. So I appreciate that. Some quick comments. Your prepared response was on target. It tracked the question. It provided a breadth and depth of evidence to support your points of view. You presented an argument, not just a bunch of opinions, but you substantiated your positions with reasons and evidence in most cases. That's great. I just really love, I'm a dork, but I love like data. And you guys brought in 3.2% of writs are granted and only 1.6% of those are even acted on. It's like, wow, right? That's good stuff. I mean, that closes out arguments with just power. And I just love that. Keep thinking about this stuff, right? This is tricky business. You've got the January 6th events at the Capitol, but that you've got the BLM movements over the last couple of summers. How do we find a way to consistently or fairly apply these things when there may be a lot of other interests behind those decisions? I feel good that you all are young people going to be moving forward, and I think you'll take care of our country. And I appreciate you all, and congratulations.
Thank you.
So over the course of this afternoon, I think this is the 12th conversation, whatever, on habeas corpus. This is the first time Charles Crittenden has been brought up, and that's a fine thing to hear. I appreciated that you folks know your state constitution, and we're referencing your state constitution. So I live in Illinois. I'm a relatively informed citizen. I have 2 degrees in history, and I've only just recently started to learn what's in my state constitution. So I tip my hat to you. That's I mean, in all seriousness, it's very important. Going forward, I mean, I imagine there's going to be a legal career in the future for at least one of you at the table, and I think just a good piece of advice, you can strengthen your own argument if you present the other side's argument in like the best possible light and then just annihilate it, as I'm absolutely certain you'll be able to do that. So but that'll strengthen your side along for sure. I would have, I mean, even though it's at the end of the day and I'm just utterly exhausted, I would have loved to have done 20 more minutes with this. I would have played devil's advocate. Some of the stuff you guys said I agreed with. Some of the stuff you said I disagreed with. But what I like more than people agreeing with me are smart people that make sound arguments that are supported by fact and data. So this was a lot of fun, and you did quite well. Very good job.
Thank you.
Yes, nicely done, and congratulations. And again, thanks to your teacher, and commendations to you folks for all you've put into this. It was, as my two colleagues have said, it was enjoyable, and you made it an easy conversation, which can only happen if you're well informed. And you made some logical arguments backed with information, and as has been pointed out, actually, had I gotten another question, I wanted to follow up on the low percentage you said and get your opinion on why that's the way it is. I too enjoyed your reference to your state constitution as well as some other state constitutions. And so and rational thought was illustrated through that conversation. So well done, Montana. It's enjoyable to listen to you. We wish you well with this competition, as well as I'm sure successful careers down the road, and good luck.
Thank you.
Okay, very nicely done. I wish you a wonderful evening. This was the last testimony, not only for you all, but for this group of judges that